Great calling.
Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us. This hour, we are watching together this testimony in the Kouri Richins murder trial, where the state of Utah is accusing her of lacing her husband's cocktail with a lethal dose of fentanyl. And they say that she did this because she wanted to collect on his life insurance policies. Her defense paints a different picture, saying that Eric Richins ate a THC gummy, that it had fentanyl in it, and that's why he died. So let's get you back into court now. Outside of all of the drug issues, is this financial issue. A forensic accountant is talking about the issues that she was having with debt at the time. The state says that was part of her motive to kill for life insurance money.
Ma'am, did you trace this check?
I did.
If we can go back to the main document, Scott. Can you show your tracing of this check?
Sure. Scott, if you can scroll down. Okay. Right there. So mid-screen, you see April 30th, the deposited check item for $36,000 to go over there. And so that's that check. And they're included in this exhibit is the deposit slip, so I can match that up, plus the check copy came with this, so I know this is the same $36,000. And then Sorry.
At the time that was deposited, what was the account balance?
83 cents.
Okay. Can you pick up the tracing from there, please?
Yes. So in doing a tracing, I look at the balance at the time a specific transaction is made. And so then I have to match up, but for certain funds, other transactions would not clear the bank. So the following transaction is April 30th, that bank-to-bank transfer of $25,000 could not have been made but for the deposit of that $36,000. So I know those have to tie together. So then I'm looking for what other information will tell me that deduction of $25,000.
And where did that $25,000 land?
It's a wire out that goes to Stewart Title's Bank of Nevada, I believe.
Scott, can you go back to the main document and scroll down, please? No, I'm sorry, down a page.
No. Keep going to the wire. This one, please. Sorry.
Ms. Carrington, what information does this provide?
So this, you can see in the upper left-hand corner, it's a domestic outbound. So this is a wire that it's going out of the account. If you go down the left-hand column, it shows you $25,000. If you go to the middle column, it's from Kouri Richins. Right above her name is the account number 5244. And over on the right, it says it goes to Stewart Title Company. And then go down to the bottom left, and it says earnest money, Kouri Richins. Earnest money being kind of a deposit on a purchase of a property.
Thank you, Scott. Can we turn now, please, to a property that you referenced as Legacy Way that others have referenced as the Midway Mansion?
Yes.
Are you familiar with the property?
I am.
How so?
I have been by it several times over the last 3 years, and I have researched the recorder's documents, the deeds affiliated with that. I have submitted a grandma request, which is a request for government records so that I could understand all the Wasatch County building permit permits, the inspection records over the years, the life of that property. I have interviewed the prior owner before Kouri Richins bought it. I've interviewed the current owners. I've traced all the, after Kouri Richins bought it, tried to sell it, I have reviewed each of those 13 offers to purchase the property. And I've also looked at the bank accounts and the loan documents for her purchase.
Let's please start with the drive-by. Scott, can I get 6-7? Do you recognize this?
I do.
Is that the Midway Mansion?
It is.
State moves to admit 6-7.
No objection.
6-7 is admitted.
Scott, can you zoom in a bit? Scott, can I get 6-8, please? Ms. Carrington, do you recognize this document?
I do.
What is it?
This is the real estate purchase contract, commonly known as a REPC, that K. Richins Realty submitted to as her offer to buy the property in December of 2021.
The state moves to admit 6-8.
No objection.
6-8 is admitted.
Scott, if you could zoom in, please, on that first kind of top section. Ms. Carrington, what information does this provide?
So this tells us in the far upper corner, this is Sierra, and that's the bait stamp that identifies that this came from Sierra West Capital, Matt Strong being the primary lender. It gives, and then if you go first line kind of over on the left, 2/23/2021 is the date. K. Richins Realty is the buyer. Douglas Roy Lance is the seller. And then a couple lines down on the right says the earnest money deposit of $50,000. And then as you go down, it gives the street address is 106 North Legacy. That's why I call it Legacy Way. It's in Midway. That's why people call it the Midway Mansion. And then the parcel number, et cetera.
Then it says C addendum. We'll get to that one in a minute. But Scott, if you can scroll down. What information does the purchase price paragraph provide?
So it tells us what the agreed purchase, well, the offered purchase price is $2.9 million for this property. And then the accounting on the left shows that there's a $50,000 deposit, and then the balance will be paid at settlement, and then the purchase price there. And then I know that this is accepted because it's got initials on both and the dates on both, the buyer and seller.
Scott, can you just scroll down all the way through the next page? Keep scrolling. Keep scrolling. Keep scrolling. Let's stop there. Thank you. Let's zoom in on the contract deadlines through the signature. Yep. Thank you. Ms. Carrington, what information does this provide?
So this gives a chronology of different steps that need to be taken. It's very typical in every transaction, most transactions. Sellers have a duty to disclose any of the warts and problems with the house. Those are due by January 7th of 22. Due diligence means that's the opportunity for the seller, that's an opportunity for the potential buyer to do any homework, anything that they need to do as far as due diligence before they sign. That's due February 4th. Financing and appraisals, that's also for the buyer to arrange financing, funding, do any appraisals that they want to do, and they have until January 7th to do that. and the settlement deadline. That means this deal has to close by March 4th of 2022.
Does that March 4th date hold any significance in this case?
Yes, it does.
What's that?
That's the day that this property deal closed, and Kouri Richins purchased this house.
Did she purchase it on March 4th or March 5th?
I'm sorry, March 5th. March 4th is the date that Eric Richins died.
Thank you. Let's discuss the warts and problems, please. Scott, if we can go down to just keep it up, zoomed out, right there. Is that the addendum that was referred to earlier?
Yes, it is. Addendum 1.
Okay, I'm going to walk up and present you with a printed copy of 6-8. And this is the addendum, am I right, that discloses all the warts and problems?
Yes.
I've circled a few of the paragraphs on that disclosure, that addendum. Can you please read those paragraphs aloud to the jury?
Okay. Bear with me. This is paragraph 2. Buyer is to acknowledge and affirm and agrees that these parcels, parcel 1, parcel 2, are sold as is. Buyer acknowledges, affirms, and agrees that both building structures have extensive vandalism, theft, as well as flooring and other structural concerns that may need or will require replacement or repair. Due to delays in construction and the permitting/approval process, the structures have been idle, exposed to the elements, and are not habitable, and are also suitable in many ways for continued construction. Damage has occurred because of the idle status of the projects. Buyer affirms buyer's intent in moving forward with the building project or abandon the project altogether based on buyer's own investigation of said structures in their state of idleness, disrepair, unfinished, and uninhabitable quality. Additionally, animals may have taken up residence in the ventilation systems for which there may be additional damage. Buyer acknowledges and affirms that buyer accepts the property in its unfinished, disassembled, unrepaired.
Okay, we're hitting the pause button on this financial information, and we'll get back to Utah after this break. But before we do that, an update on a monumental verdict for the state of Georgia in the case of a father who was of an accused school shooter.
Jury verdict. Count 1, murder in the second degree. We, the jury, find the defendant guilty. Count 2, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 3, murder in the second degree. We, the jury, find the defendant guilty. Count 4, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 5, involuntary manslaughter, unfaithful act. We, the jury, find the defendant guilty. Count 6, reckless conduct. We, the jury, find the defendant guilty. Count 7, involuntary manslaughter, unlawful act. We, the jury, find the defendant guilty. Count 8, reckless conduct. We, the jury, find the defendant guilty.
You heard it there earlier today. Colin Gray found guilty on all charges, including second-degree murder for his reckless conduct before a mass shooting that killed 4 people and hurt 9 others. That jury deliberated for less than 2 hours, ultimately siding with the prosecution and rejecting the lesser charge of involuntary manslaughter for the 2 children killed that was on the table. His son, Colt Gray, has yet to go to trial. Surveillance video used as evidence in Colin's trial appeared to show the then 14-year-old carrying an assault-style rifle on the school bus before he allegedly opened fire at Appalachian High School back in September of 2024. These jurors believed Colin Gray was at fault for giving his son the gun after being aware of his mental health issues and a previous threat that was investigated a year before the school shooting. Colin Gray is the first parent charged and convicted in connection with a school shooting by a child in Georgia. He faces 10 to 3 years for the murder charges and 1 to 10 years in prison for each of those manslaughter charges. A sentencing date has not yet been set. Testimony continues, though, in Utah in the Kouri Richins murder trial. We'll have that when we come back. Plus, some interesting news for Sean Diddy Combs following his conviction on federal charges. How soon could he be released from prison? We'll talk about it on the other side.
This is the story of the Richins. Eric, a father of 3, met an untimely end, and Kouri, his widow, wrote a children's book on grief.
She's also charged now with his murder. He was faced with betrayal and terror.
I know her innocence.
Is their story a tragic romance?
Or a twisted tale of greed?
The truth will come out.
The Grief Author Murder Trial. Live coverage weekday mornings, 8, 7 Central on Court TV.
Welcome back. We are watching the Kouri Richins trial out of Utah. But before we get you back into the courtroom, let's get an update on some of the other cases we are tracking. In Massachusetts, a trial began today for a woman charged with assaulting her husband. She claims she was the victim and only defending herself. This is Lucy Medina, indicted on charges of aggravated assault and battery after using a knife to cut the throat of her husband, Luis Medina. He survived that attack and even sent a letter to the court saying he believes his wife did not commit a crime and acted in self-defense. And in New York, Sean Diddy Combs to get out of prison nearly 2 months earlier than expected. Combs was found guilty on 2 counts of transportation to engage in prostitution back in 2025. The Federal Bureau of Prisons website is now noting that the Bad Boy Records mega producer is now set to be freed on April 25th, 2028. It was originally showing him to be released on June 8th of 2028. And in Michigan, court ended early today in the hidden murder of Dee Warner trial. Dale Warner faces life if he's convicted in the killing of his wife Dee back in 2021. The defense rested its case today, so both parties are going to come back on Thursday for the closing arguments. Now back to Utah, the case against Kouri Richins, who's accused of killing her husband Eric Richins by lacing his drink with fentanyl. But the defense says no, he took a THC gummy that was laced with fentanyl. That's what caused his poisoning death. On the stand right now, though, is someone the prosecution says can help this jury understand the motive. A forensic accountant is going over the real estate company records for the defendant, where at times she was in debt of up to $7 million. That accountant is still on direct examination, talking about some issues with taxes.
Agrees to confirm through buyer's own due diligence which repairs and remediation efforts are necessary. Buyer acknowledges and affirms buyer's own actual or potential costs of repair, remediation, demolition, remodel, restart, reconstruction, and or completion in moving forward with the building projects. Buyer agrees to purchase and accept the parcels, buildings, structures, and all aspects of the purchase of said parcels on an as-is basis and waives and releases any and all claims against seller or any deficiency, unexpected outcome, or unknown condition, cost, delay, failure, or liability. Paragraph 3. Buyer acknowledges, understands, and affirms that sale of said property is sold without all or necessary or desired permits, certificates, or allowances to build or complete the building process from Wasatch County or other governmental agencies. And buyer is said and buyer is to be solely responsible for obtaining any required building permits from Wasatch County or any other necessary government entity. Buyer acknowledges, understands, and affirms that seller's building process was halted by the governmental permitting or allowance process, and as such, buyer intends to purchase these parcels as is, with full understanding that buyer may also face challenges and costs in obtaining necessary or desired permitting allowances to build, rebuild, or complete the building and occupancy process. Buyer acknowledges, understands, and affirms that the structures do not have certificates of occupancy, necessary approvals through all required inspections, and other indicators of structural habitability. Paragraph 4. Buyer acknowledges that seller has been working with the Army Corps of Engineers over a lengthy period of time, and that this entity is currently requiring additional wetlands evaluation of various materials, including water, environmental, etc. The Army Corps of Engineers may require other tests, requirements, and certifications, etc., that are to be completed to their satisfaction. Buyer acknowledges, understands, and affirms that the Army Corps is an independent government entity separate of Wasatch County, and that the Army Corps may require its own permitting, which Wasatch County may also require in order to obtain building permits. Buyer acknowledges, understands, and affirms that the Army Corps of Engineers does not monitor or collaborate with Wasatch County in any way. Wasatch County may or may not issue building permits independent of the Army Corps of Engineers. Buyer acknowledges, understands, and affirms that buyer, not seller, is responsible for moving forward with the Army Corps of Engineers and all other governmental organizations that may have oversight or control of the parcels and building projects and occupancy certification processes. Buyer acknowledges, understands, and affirms that the process of moving forward could take considerable time, present costs, delays, hardships, and burdens to buyer. Buyer acknowledges, understands, and affirms that buyer does not require any contribution from or assistance of seller with regard to obtaining all necessary permits, certificates, allowances, or approvals to restart the building process or complete said process and obtain all necessary inspections, approvals, certificates, permits, or allowances. Paragraph 5. Buyer acknowledges, understands, and affirms that the parcels have sewer rights, but that the sewer is not yet hooked up, is below grade, and will have to be pumped. Buyer acknowledges, understands, and affirms all necessary steps to obtain sewer function is the responsibility of the buyer and may be required to be on site on the subject parcels. Paragraph 6. Buyer acknowledges, understands, and affirms that additional or dedicated open space, i.e. wetlands, or other required remediation or mitigation may or will be required by the Army Corps of Engineers, and that to achieve mitigation or remediation, additional properties may be required for such. Thus, a potential off-site property may be obtained by the buyer. And if not on an additional off-site property, then remediation or mitigation may or will be on-site the subject parcels. There is a mitigation process that will need to be coordinated with the Army Corps of Engineers. Buyer acknowledges, understands, and affirms that there may or will be costs related to preparing lands to offset any disturbed wetlands. An outside consultant with BioWest has collected data and submitted data and recommendations to the Army Corps of Engineers. The Army Corps of Engineers still need to make its final decisions and will determine a mitigation plan with permits in cooperation with buyer.
A lot of words being read there inside of the courtroom to this jury from that forensic accountant who was on the stand. Let's bring in criminal defense attorney Silva Megerditchian, see what she thinks about this stage of the Kouri Richins trial, the forensic accountant. We see this sadly in so many murder cases where money is the alleged motive. Silva, what do you think about where we are right now?
Well, hi, Julia, and thank you so much for always having me, and much love and adoration to you. Julia, look, it's the prosecution's doing a laborious case. It's a little bit boring, to say the least, only in that it's so thick with evidence and information that might be a little bit useless to the jury. But I think we are establishing something that is the most important thing for consideration in a trial, and that's motive. And they're doing it in a very interesting way. First of all, this testifier, this witness, is so credible and so good at what she does. She's a forensic accountant. She's to the point. She explains things in layman's terms. I'm really impressed with her testimony. And she outlined a very direct motive for this case. It is very clear that she had a lot to gain from her husband's death and a lot to gain to get her out of the hole. And I think it's I think this, along with the Google searches, I think both of these pieces of evidence is really going to stick out in the jurors' minds as to motive and reason to kill.
Yeah, those Google searches, not good for the defense in this case. Yeah. And when I'm seeing so much come in, especially from a forensic accountant who's got to explain all these finances, it's reminding me of the Alec Murdaugh case. It's reminding me of the Paul Canero case, where you had to take these jurors through the financial depths and just to show how much pain financially they would have been in, because I think it is important for the jury to understand this wasn't just regular business carrying these amounts of debt. This is something that they were drowning drowning in. How lengthy do you think is too lengthy for them to spend deep in the finances in a case like this?
You know, Julia, I think right now the prosecution is invested in this. So they're going to, I think, despite if the jury looks tired or uninterested, I think they're just going to stick to their notes and their questions and get through this. Again, they are so lucky to have such a credible witness who is really good at explaining. And I think you said it best last hour, Julia. She's doing such a great job at explaining things that it's even above the head of the prosecutor and the defense, but it's very pinpointing as to the strongest motive. This is a motive for divorce. This is a motive to kill. This is a motive of drowning so deep in debt, which we know causes marital problems beyond words. But how can she get out of it? The only way she saw how, the prosecution is going to argue, is getting the money from her dead husband, because his prenup was so tight, she couldn't get it through a divorce. It's incredible testimony, and Julia, you're absolutely correct. In all of these high-profile cases, the bottom line, it's either money or jealousy or a little bit of both, and we got that here.
It is a tragic mix when we see it like this, but the defense says it really wasn't that bad and she would have gotten more money if he'd stayed alive. So we'll see what happens with the cross. Silva, stand by. We've got to get to our break. More testimony from that forensic accountant on the stand there in Utah when we come back. Welcome back to Court TV Live. I'm Julia Janae. Back to Utah we go, where day 7 continues for the trial of defendant Kouri Richins. She's accused of killing her husband with a Moscow mule spiked with a deadly dose of fentanyl and then writing a children's book about grief to gain sympathy. The defense says, though, that it was a self-inflicted overdose by her husband. On the stand now is a forensic accountant. Let's pick it up where we left off.
Ms. Carrington, in your experience reviewing REPSIs, have you ever reviewed a REPSI like that?
No.
Scott, can you please bring up 6-9? I will retrieve the exhibit. Thank you, ma'am. Ms. Carrington, do you recognize exhibit 6-9?
I do.
What is it?
This is the settlement statement for the Legacy Way Midway Mansion property, where Kouri Richins Realty is the buyer and Douglas Roylance is the seller. And this is the final version of the sale.
The state moves to admit 6-9.
No objection.
6-9 is admitted.
Ms. Carrington, what information does this present? And if it's easier to step down, please do it. I don't know what's easiest.
It might be, since I don't have a... Thank you. Okay, this is not actually as complicated as it appears. So this is the property address here, the buyer, the seller, and the lender is Sierra West Capital. So that's the Sierra West Matt Strong stuff. So over here shows the settlement date and the disbursement date as March 4th of 22. And then this is the internal file number at the title company. This shows the sale price. This is the buyer's version. There is a seller's version, but this is the buyer's version. This is the sale price of the property at $2.9 million. And then here shows 2 of the 4 loans on this property. So here's the original loan from Sierra West to this $2,624,850. There's another lender from the Burns, and that loan is $420,000. These are some prorations. This section here, are you all right if I keep going?
Please, what's that section there?
This section, these are the fees associated with these loans. So the first position lender is Sierra West Capital. this $2.6 million loan, they charged $124,850 at the outset just for the loan. And then on top of that, it accrues interest going forward. It's a 6-month balloon. So this being March 4th of 22, she has to pay that off by September 4th of 2022. The next two, the $150 and the $20,000 relate to this loan, the $420,000 by the Burns. And then Scott, could you please scroll down? Thank you, that's great. So then here, these are the title insurance costs that are paid to GT Title Services, who's the title company in this transaction. So these are the different costs associated with that. So the first one, the lender's coverage premium, that's for the first position, the Sierra West one. Second position is the Burns, the $420,000 one. The third position loan is going to be this. For some reason, this is down here. I don't know why. But this third position lender funds is $150,000. That's an aggregation of a bunch of people who got together and they pooled their resources to loan $150,000 on this deal. And here is the buyer's portion of the real estate commissions, the 2% at $58,000. The other side paid $1,000 per their agreement, and then some recording fees. On top of this, there's one more loan from David Cockerhands that came in before this. He gave her the money for the earnest money. So did Matt Strong. So they both gave her the $50,000 for the earnest money. But later, the fourth position lender of $67,000 recorded his deed. I don't understand why it's not incorporated here, but it's not. But it is still attached and recorded on the property. So this tells us that all in all, there needs to be $3,201,230 that the buyer needs to come up with. And as I said, there's also that other $67,000. So she borrowed $3,259,000 against this property to buy it for $2.9 million. And then there was a little overage. And so this $87,240 came back to her. And we can see that go back to her bank account, and that hits her bank account.
So does this show that she borrowed $3.2 million from other people to close on a $2.9 million house, and at closing she walked away with $80,000?
$87,000, yes.
On the day that the Midway Mansion closed, how much was it worth?
$2.9 million, because that's what she paid for it. That was the agreed price on that for that transaction.
Is the real estate market like other markets in that the value of something, whether it's gold, oil, real estate, the true value on any given day is what a willing buyer and willing seller agree to?
Yes, and so in addition to the fact that that's what the market dictates, the IRS rules also say that a transaction is valued between a willing seller and a willing buyer, and industries function like that all the time. Business valuation, a forensic accountant who conducts a business valuation of a business will use that same concept.
Did you use that same concept in valuing all the properties involved in this case?
I did, because that's what she paid for them.
Scott, can we get 5-114, please?
Sure.
Bless you. Ma'am, do you recognize this agreement?
I do.
What is it?
It is a loan agreement reflecting that large loan between Sierra West Capital and Kouri Richins Realty. And this was a response from the title company, Griffith and Turner Title, in response to a prosecution subpoena.
Your Honor, the state moves 5-114 into evidence.
No objection.
5-114 is admitted.
I really do wonder what this process is like for the defendant sitting there. The prosecution alleges that she knew all of the problems she was having financially. It was robbing Peter to pay Paul, and now she is seeing it all laid out in court in front of everyone. Let's get to a break. When we come back, we'll go in for more of this pivotal testimony for the prosecution in their case against Kouri Richins.
On Court TV.
I'm Vinny Politan. Welcome to Closing Arguments. We have a big hour ahead here.
Your deplorable actions are unforgivable.
The community still doesn't know how this Boston police officer died.
He can't prove one element of his case.
It was a dramatic day, a dramatic moment inside the courtroom.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Weeknights at 8, 7 Central. Only on Court TV.
$7 million. That's how much debt the prosecution in Utah says Kouri Richins was drowning in, and that it led to her looking to murder to solve it. But the defense says they have it all wrong, that her late husband knew about her business ventures and that he was worth more alive. Let's get you back inside of the courtroom. We're listening to a forensic accountant who's talking about all those millions the defendant borrowed.
Am I right? Is this the loan agreement between Kouri Richins Realty and Sierra West for the Midway Mansion?
It is.
And Sierra West was the biggest lender at $2.6 million.
That's right, yes.
Scott, could you just scroll down on page 1? Scott, could you go to page 12, please? And is this part of what is, are we looking at what is known generally as a closing packet?
Yes, that would be consistent, yes.
These are the closing documents on the Midway Mansion, at least the closing documents for the largest funder on the Midway Mansion.
That's right, yes.
And is this the signature page?
Yes, it is.
And is that signature notarized on the 5th of March?
Yes, that's correct.
Scott, can you go to page 21, please? Is this another different signature page?
Yes, this one is basically acknowledging that the company that's buying this authorizes Kouri D. Richins to act on its behalf.
Scott, can you go to 27, please? Is this yet another signature page in the closing documents?
Yes.
Can you go to 32, Scott? I'm sorry, yeah, let's just go to 32. 32. Is that yet another signature page in the closing documents?
Yes.
And 33, Scott? Ms. Carrington, is that yet another notarized signature page in the closing documents?
It is.
Thanks, Scott. Ms. Carrington, based on your analysis, did Ms. Richins have the ability to service the $3.2 million in debt when it came due in 6 months from closing?
She did not.
Scott, can I get 2-14, please? Ma'am, do you recognize this document?
I do.
What is it?
It's an email string between Matt Strong and Kouri Richins that was returned pursuant to a prosecution subpoena from Sierra West Capital and Matt Strong.
And does this email string in part discuss how much money Kouri Richins estimated would be required to finish the Midway Mansion? We can scroll through it.
Yes. This is the one where she's asking him to loan her the earnest money, the $50,000 for the project.
In part, yes.
Right.
The state moves to admit 2-14.
No objection.
2-14 is admitted.
Scott, can you publish that part you had highlighted on our screens?
Scott, let me know when you're ready. Okay.
I'm going to give
Okay, while they take that pause in court, let's bring back in criminal defense attorney Silva Megerditchian, who is watching along with us. I was watching Kouri Richins' face, Silva. It seems like she is maybe more involved and active when it comes to this portion of her case.
Yes, you know, Julia, I've been watching her intently as I've been watching this trial. Look, I got to give it to her. We've seen so many defendants make so many different faces that were just like, oh my God, can you stop? I actually think her emotionless. She's very stoic. You know, she seems surprised with some things and completely upset with others, but she always is in control of her facial expressions, something that most attorneys can't even do. So I actually think she's doing quite well. But Julia, you said it before, this is incredibly difficult testimony for her to listen to. It not only puts her financial disasters on a nationwide television screen, but again, it's powerful evidence of a reason to kill. So if she chooses to testify, this is the most important aspect that she must address, and address aggressively, because in the back of jurors' minds, there's nothing more powerful, Julia, I think even more so than DNA evidence, is motive evidence that really carries the day in the jury room.
Yeah, motive that the prosecution doesn't have to prove, but it sure looks good inside of a courtroom. Make an argument for the defense, though. These are this husband and wife team, they're two business people, maybe have a large appetite for risk. How are they going to frame this when they get to cross?
Oh, Julia, that's such a great question. You know, I really do salivate at this because there's a lot of ways that the defense attorneys can twist this depending on what she told them. For instance, these were two very independent couples. You know, she had her own business dealings. He seemingly didn't interfere in hers, and she seemingly didn't interfere in his. In fact, the prenup is evidence of that, right? What my business is my business. So it would be a natural inclination to think Kouri's business is hers and hers alone, including her debt. That's what they have to argue.
Fantastic. We'll be looking out for that when this cross-examination happens. Silva, we always appreciate your great expertise. Thank you so much for coming on. When we come back in the next hour, the witness is going to be asked about the $3 million Richins claimed to have for renovations of the Midway Mansion, and the state looks more into that.